Good morning, everyone. If you've been to one of Treelaw's conferences before, then welcome back. And if you haven't, then welcome. We've got a really fantastic few hours lined up for you. We've also got Treelaw's 4th birthday swiftly approaching. So thank you so much for taking the time out of your very busy schedules to be with us this morning. Our speakers today include Neil Davis, Naomi Bailey, Adam Cormack, as well as Treelaw's founder and director, Sarah Dodd. And we will get underway with Sarah Dodd's keynote session very shortly. You'll notice that you can't toggle your cameras or your microphones during the session, and that's just to avoid any disruption to the speakers while they're giving their sessions, but you do have access to the chat, so please use it. I know that a lot of you will have some really insightful comments and contributions, so please leave your comments. And also we'll have time at the end for a Q&A, so pop as many questions as you can in the chat there. I'm just going to finish up now by saying, if you don't already, please follow Treelaw on all social media channels. We're on all of them, Facebook, Instagram, TikTok, and we've also got Treelaw TV, which is our YouTube channel. And also take a look at our website, where we've got loads of blogs and articles, most of which are written by the team here at Treelaw. And so with that, I'll hand over to Sarah Dodd.
Thanks, Don. Brilliant. And a very, very warm welcome to everybody. Thank you so much for coming to this year's Treelaw conference. Well, I will go straight in with the keynote session, which is about a recent TPO prosecution case that I was involved with that changed a little bit of law. So it's of significant interest. Let me just share my slides. Yeah, I hope you can all see myself to the side slightly so I can see my own slides. So as I said, this is about a TPO prosecution that I dealt with for my planning authority client here, who council. So these slides are quite wordy, but I really wanted to get the story across to you guys. You can see what happened, how the investigation went ahead, and then what happened in the prosecution. So what we were dealing with here was a domestic property in Newport that was built in 2002. At the time of the construction, a TPO was placed on a row of 8 lime trees by Newport City Council, and there was comments in some of the planning files, I think, about it being a magnificent row of lime trees and a really standout set of trees in Newport. 2 of the protected lime trees themselves were in the rear garden of the subject property. The property overlooked an area called Barrack Hill, which is a nature reserve owned by Newport Council. Various planning applications had been made by the homeowners over the years to their property. They'd done quite a few extensions, small additions, and they'd made numerous applications for works to trees over the years. There was a prior application to fell one of the lime trees, which was rejected by Newport in 2011. Fast forward then to summer 2023, and a member of the ecology team from Newport was out working on Barrack Hill. When she was there, she looked up the hill to the rear of the property and noticed some significant pollarding work of the lime trees, and that caused a concern because she could see that they looked, I think they were pretty brutal. That was the comment. She contacted and someone from planning enforcement, and they went out to visit the property. So I think either later on that day or the day after, they went and visited the property. So when they went, they visited the property to investigate the one lime tree that had been pollarded. And when they got there, they saw that one lime tree had been pollarded, and then they also saw that the second mature lime tree that should have been in the garden was no longer there. So we relied quite heavily here on Google Images because questions were asked as to when that mature lime tree had been removed, but we were never given that answer. So Google Images of the property showed that at some points between 2013, the lime tree had been removed from the garden. Sometime after its removal, it had been replaced with a small sapling. So there's a period of time where there's sort of nothing, you could see nothing in the garden. And then one of the later Google images shows that a sapling had been planted. It was clear that this work had been done without consent. Despite asking, it was not confirmed by the defendants who had been instructed to fell the lime tree or exactly when it was done. The defendant homeowners were both charged with causing and permitting the felling of a TPO protected tree. They both pleaded not guilty and they were separately legally represented. So this was a husband and wife, still together, still living in the same property, but separately legally represented. So this claim went to a magistrate's trial in September 2024. Both defendants maintained their not guilty plea. And by this point, by the time we got to the magistrate's trial, there'd been quite a bit of, there was about a year between the charges originally being laid and the magistrate's trial going ahead. There was quite a bit in back and forth with regard to disclosure because quite significant requests had been made for disclosure. So by the time we got to the magistrate's court, I think the trial bundle and the disclosure being used was in the realm of 1,600 pages of evidence, I think it was. Both defendants continued with their plea of not guilty at the magistrate's trial. And given that it was a strict liability offence for felling of a protected tree, it was interesting to see what points the defendants were going to raise in their defence. So what they raised was, their first point was that the TPO itself was invalid. So if the TPO was invalid, then the tree wasn't protected. It was a tree in their ownership, so it was their choice to fell it or not. The second point was that it was not the law in Wales that you could be guilty of causing or permitting the felling of a TPO protected tree, because as you might know, section 210(1)(c) of the Town and Country Planning Act isn't in the law in Wales, it's only in England. And then thirdly, that the tree itself was dangerous as it had been damaged by a wildfire on Barrack Hill in 2012, so the danger exemption applied. So that was their 3 points. TPO invalid, causing or permitting isn't possible in Wales, and if it is, then the tree was dangerous and they exercised their rights under the exemption. So the prosecution evidence, acting for Newport, the prosecution evidence that we gave was a variety of both witness evidence and expert evidence. So in terms of witnesses, we had Shona Carl, who gave a very detailed breakdown on the process of making the TPO, why the trees were deemed appropriate for a TPO, and the course of making the TPO during the construction of the small housing estate. Then we had Neil Gunther from Planning Enforcement and Paul Kane, the tree officers from Newport, who both gave statements on what was found at the property when they first carried out their site visit, and what was found on site in terms of the missing tree. We then had expert evidence. We had Ken Shepherd giving arboricultural evidence on the tree, the loss of the tree, and also, I think that went into caveat value. Ken could probably tell me if that's right or wrong. And then finally, we had an expert report from Professor Claire Belcher, who was instructed pretty late on in the claim, and it was to address the issue of the danger exemption. So Professor Belcher is a professor of wildland fires, and what we needed was some input into whether the tree itself would have been damaged by a wildland fire or actually would have been prone to setting on fire had there been a fire on the Barrack Hill grasslands adjacent to the property. And then very finally, we had some valuation evidence from a surveyor, a RIC surveyor. We wanted valuation evidence to let the court know what the value of the property was before and after the tree removal, so the accrued value. So that dealt with things like an improved view, because the property is sort of up on a hill, so remove the tree and you have an unencumbered view over part of the grasslands and Newport. And then also potentially an increase in planning opportunities due to the tree no longer being there. The defence evidence was there's a little bit less defence evidence. So in terms of the witness evidence on the box, the homeowner, the husband, Mr. Homeowner, as I've called him, he gave evidence about the tree, about their perception of the risk and danger caused by the wildfires in the tree. And then they also had expert evidence from Dr. Smith, so from a wildland fire expert. And actually, Dr. Smith and Professor Belcher, in terms of the wildland fires, were almost totally in agreement on their opinion in the end. So the verdict, at the Magistrates Court, the verdict was the TPO itself was found to be valid. So that was great news for Newport. There was found to be no against Mr. Homeowner. That's because the judge found that she couldn't say that he was aware of the work that was being done to the tree. It really was quite a division of labour between Mr. and Mrs. at the property. Mr. was a businessman, owned a business, was often away with work, travelling. Mrs. was a housewife, dealt with all of the issues at home with the children and in the garden. And the judge said that she couldn't find that Mr. knew about what was happening. And it was she couldn't say that it was anyone other than Mrs. who'd arranged for the tree work to be done. So there was a guilty finding against Mrs. Homeowner and no case to answer against Mr. Homeowner. So at that point then, the case was sent to the Crown Court for sentencing. So we were all ready to go to the sentencing hearing, and then shortly before, Mrs. Homeowner lodged an appeal to the Crown Court. So the appeal is what went ahead in August of this year. I think it was only a couple of weeks ago. And actually, it was that appeal which meant that today's conference had to be moved from the original date in May to this date in September, because I really wanted to be able to cover off this case and the outcome. So the appeal was at the Newport Crown Court and was heard before Her Honour Judge Celia Hughes. There was one point that was dealt with in terms of the appeal, which was the basis that the defendant said that in Wales there is no offence of causing or permitting a breach of a tree preservation order, and they felt that the decision that had been made by the Magistrates Court was incorrect. So that hearing went ahead on the 25th of August this year, and the outcome of the hearing was in our favour, which was excellent news. So the key piece of information which is of interest to planning authorities across Wales and even in England and wider is that despite section 210(1)(c) of the Town and Country Planning Act not being live in Wales, it is still possible to be prosecuted in Wales for causing or permitting the felling of a protected tree. Now, this has been an area of law which has been a bit of a gap. It's a gap that the Senedd are aware of, and it's a gap which should be closed when the new planning law comes into effect in Wales in 2026 or 2027. But for the moment of time when between now and then, it's great to have this clarified. So in terms of causing or permitting, what the case has set out is that causing or permitting can be read into Welsh law by the application of the R versus Bournemouth Justices case, in which the Lord Chief Justice said that causing or permitting works is just as much of an offence as actually doing them. And the judge said it would be contrary to common sense, logic, and in the interest of justice if a householder could only be prosecuted for a more minor offence. So in terms of sentencing, so once the appeal was unsuccessful, so our guilty finding against Mrs. Homeowner remained, we moved straight on to sentencing, so later on in that same day. And at the time of the act, so the actual act of felling the tree, as you know from earlier slides, we don't know exactly when that was, but we know it was between 2010 and 2013. The maximum fine in Wales at that point for the illegal felling of a TPO protected tree was £20,000. So the judge started off by saying she was working to a maximum of £20,000. She then went on to say there's no sentencing guidelines at play here, but case law sets out that there are three elements that she had to consider, and those are financial gain, damage, and culpability. So she went through each of those in quite a bit of detail. So first, in relation to financial gain, the judge said that she had read the RICS valuation evidence, And actually that valuation report said that the impact on the value of the property caused by the felling of the lime tree was that the property's value had increased between £50,000 and £100,000. So the judge, having read that, concluded that on the basis of the valuation evidence, she concluded that there was a £50,000 gain to the value of the house. Moving on to damage then, this was all about damage and the fact that the defendant knew of the TPO and had made previous applications but had been refused. So there have been a variety of applications that had been made at the property over time, some relating to trees, some relating to the property itself. But the last TPO application was made in 2011, I think, that was for felling of the lime tree, and that had been refused. So there had been a replant of the small replacement lime, but that was found not to mitigate the loss. And actually the defendant brought up on screen a current photograph of the lime, which has grown, but still found not to be hasn't mitigated the loss of the mature tree. And the judge was very clear that she felt that this was a deliberate act. In terms of culpability, whilst the defendant, so Mrs. Homer, might have held the subjective belief that the fire damage might have been a danger, the small factor of the subjective view of any danger cannot detract from the arrogance of blatantly disregarding the TPO. And I've put that in inverted commas because that was word for word what the judge said. So there's no doubt that there were wildfires that occurred on Barrack Hill. That was an area of grassland which was directly behind the homeowner's fence. This lime tree wasn't on the fence line. This lime tree was in the middle of the garden. So there was quite a gap of grass between the tree and the fence line. I think it was at least a metre. I might be right, it might have been a little bit more. But what the situation was that the defendant had a reasonable belief that that tree could well catch fire as a result of those grassland fires. That was her understanding and that was her concern. But actually it came out from the fire evidence from Professor Belcher and also agreed by the defendant's experts that lime trees are actually fire retardant and can actually be planted as a fire break. So in reality, objectively, they wouldn't have been a risk. So that was a really interesting point about the fire evidence. My first time of having fire and risk of fire being brought up in a tree-related case. So in terms of the fine, as I said earlier, the judge said she was working to a maximum of £20,000 as a fine. She set the fine at 16,000. She didn't say any more reason as to why she wasn't going to the maximum, but she set it at 16,000 and then gave a costs order against the defendant of 100,000. Now I know that I've seen comments on this split in Facebook chat and a little bit on other social media posts. And there's been questions about why costs were so high for this sort of prosecution. Well, the costs were high in this because of the value of the points that were being raised by the defendants. I'm not sure the defendants realised the political nature, perhaps, of the points that they were making in their defence. So they were arguing, as I said earlier, that the TPO was invalid, and they were arguing about the law in Wales being different from England. Well, both of those had quite a significant wider impact. So had, for example, the TPO being invalid point succeeded, then Newport were facing having a county with no valid TPOs in place, because the TPOs across Newport were the same, the process used was the same. And if there was a risk that the judge was going to find that the process or the document itself was invalid, then there was a huge project facing Newport of having to reinstate every single one of their TPOs. They estimated that that would have been a 1-year project for somebody to do, and also would have had a devastating impact across the county, because word would have got out that no trees across Newport were protected by a TPO until the new TPOs had been put in place. So that argument was of significant concern for Newport. And then secondly, the point about causing or permitting. Whilst it was Newport raising that point that the law in Wales is the same as England, they were really going into bat there for the whole of Wales. Now, this is a question that planning authorities across Wales have got. So it was really important that that point was robustly argued, because it was going to determine basically what Newport and other planning authorities in Wales could do in relation to TPO prosecutions between now and the new planning bill coming in 26 or 27. So when the judge was looking at costs, so she had a full breakdown of costs, she had all the figures in front of her. The defendants were trying to argue that the case only succeeded against one of them, so the cost should be reduced in half, but the judge wasn't having that. The judge had to consider basically what was just and reasonable, and she did that based on the arguments that were raised. It wasn't simply that Mr. and Mrs. weren't entirely different claims, they were separately represented, but whether the claim ran against one or the other wasn't going to make, one, the other, or both wasn't really going to make a significant impact on the costs incurred by the prosecution. And as I said, the importance of the wider political points had been emphasised. The judge made a key point here and said that if the defendant wasn't required to pay back the legal costs of Newport, then indirectly the citizens of Newport would have to pay that. And as she said, they'd already lost the tree, so she didn't want them to have to lose even more. So out of that, then the conclusion was a payment of £116,000, which is payable in the next 12 months. So finishing off now, Newport's priority, as I've said, the key issues for Newport were the validity of the TPO and the ability to bring a prosecution for causing or permitting. The validity of the TPO issue, that would have been a huge impact on both time and cost for Newport. As I said, it would have been a 1-year project for a member of their staff. Causing or permitting, that is a key point that has been a differentiator between Welsh and English law, but it's excellent to know now that we've got the clarity that you can be found guilty for causing or permitting the felling of a TPO protected tree in Wales. So we no longer just need to sit back and wait until the planning bill comes into force. Newport argued this political point for both themselves and also on behalf of all planning authorities across Wales, finally given the clarity for the benefit of so many. And before I finish off, I just want to give a huge shout out to the Newport team. I think it's very rare that you get to be involved in such a team effort of a case such as this. There was such a lot of hard work behind the scenes. We had Shona Carl driving the case forward, John Williams, Richard Barron, Paul Kane, Neil Gunther, and Rifa from Newport, all from Newport. And then we had the brilliant Tim Straker Casey, who gave the, who was the main barrister at the trial, supported by Elizabeth Nichols, who you may recognise as a co-author of the Law, Trees, Forests and Hedges. And then we had our brilliant expert, Professor Belcher, Claire Belcher, the wildland fire expert, and Ken Shepherd. So it was a huge team effort with everybody working really hard to pull together this excellent result. So that's the end of that. I hope you enjoyed hearing a little bit about that case. Over to Neil. Thank you.
I'm on mute. I'd have to start. There's always one, isn't there, everybody? And it's normally me. There we go. That'd be fine. Okay, so I'll start again. Hello, everybody. My name is Neil Davis. I'm the head of arboriculture for Keystone Environmental. And today we're going to go back to the basics of tree risk management. It's a short presentation that's really aimed at non-arboricultural consultants, or non-ARBs as we call them. So I've seen a few folk in the attendance list that are very well known, respected ARBs throughout the industry. So apologies to you folks. Have a cup of tea, sit back, relax. Perhaps it might be a little bit of a revision for you, but yeah, this is what we're going to go through today. So we're going to go through some basics of tree management. If you fancy it, the QR code there, that's a link to my LinkedIn. Feel free to click on it. Likewise, feel free, you don't have to at all, just if you want to know more about me. So I've been in tree care industry for 29 years this week. I just had a look at the calendar and realised it's 29 years. So in that time, I've been an apprentice woodland manager with the National Trust. I've been a tree officer. I've subbed into Newport City, actually, covering leave there as a sort of part-time tree officer, and yeah, worked throughout the country. So we'll get straight into it. Okay, so one of the main things that we need to consider when it comes to tree risk management, and this is a fundamental touchstone, is that everything needs to be a balanced and proportionate approach. That all too often there's some kind of event where a tree falls over or something falls off a tree, and there's a knee-jerk reaction to go out and remove all of these horribly dangerous things, but they're really, in the majority, not that bad. So we need to remember that trees provide a wide variety of benefits to society. Trees have many environmental benefits. I'm sure everybody's heard many things and read many papers from the likes of Trees Design Action Group, the Arb Association. Many organisations publish a lot of good information about this. Trees are living organisms that naturally lose branches or fall. Yeah, they are not immune to things falling off them. Even an otherwise healthy or apparently defect-free tree may lose items here and there along the way. And normally, it's not a keep or fell question. There are many options available to manage the tree appropriate to its condition here. You can see on the right-hand side, this is an 800-year-old tree that has been managed throughout its life with these props and various works to make its existence in this monastery more suitable. And the overall risk to human safety is extremely low. This is an important thing to remember. I mean, and touching on the points of these trees, that this one's in Italy, as I say, and this one here is in Italy. This one here is in Windsor Great Park, and I visited that with Ted Green a little while back now, and we think that tree is older than Windsor Castle itself. And to sort of give that some perspective, during the lifetime of these two trees, we've had things, and I'm not a historian, so this is a quick Google search, but there was the Ottoman Empire was founded, we've had the Black Death, we've had the Ming Dynasty, Battle of Agincourt, Joan of Arc was burned alive, love her. The ceiling of the Sistine Chapel got a coat of paint, yeah, that's fairly famous. The Georgian calendar was introduced, and when these trees were about 200 years old, Shakespeare married Anne Hathaway, not the one in the movies, obviously. The Pilgrims had their first Thanksgiving in Plymouth, and we've had things like the Plague, the Fire of London, a whole bunch of wars and royals and revolutions and all that kind of stuff along the way. So these fantastic trees that we have in our landscapes and in our built environment as well, that they really are gateways to history, to culture. They're part of our human existence. So this is taken from the National Tree Safety Group's updated guidance from last year. The management of risk, when properly organised, enables the duty holder to do these things. And it's all about making sure that we take a balanced and proportionate approach. Keeping in mind, it is managing risk and hazard. So with that in mind, normally I would do this as a bit of a quiz, but as we're doing it over Teams, this is a little more tricky. So normally I would ask people to define, suggest what they consider to be a hazard. And the HSE gives it as something that could cause injury or illness, also damage when considering trees. So I used to work for a company that had an office in London. It was just around the corner there. For those of you that know London, or at least the London skyscape, that's the Gherkin there. And people used to go out at lunchtime and go to these shops and get themselves a sandwich and that kind of thing. And somebody came back and said, "Oh, Neil, I think that tree in the planter out there is dangerous. You know, could you go and have a look at it? You make sure it's okay." You go out and have a look at it and you think, "Oh, geez, well, it's a small tree. It's got a little bit of bud in it. It's got a little bit of life in it. So, you know, let's consider it. Could this cause injury or illness?" You think, well, possibly, you know, if this branch falls off and clouts this unfortunate soul by here, maybe, or if it was to fail at the stem base there and hit the same person, then sure, it could hurt them, but it's not going to cause an outrageous injury to this person potentially. And then the risk of the potential that harm or damage could occur and how seriously. So what is the risk of that person who's walking busily on their way to pick up their lunch or catch a train or whatever it is, to be right under this tree or this branch perhaps as it falls off and comes down? You know, the potential is very low. And the probability of the uncontrolled event, so this thing that is beyond our control potentially, how will that lead to injury, ill health, or damage? So we consider all of these things, as you would with any risk assessment and any management of risk, whether you're in a factory making cars, or whether you're, you know, in an office, or whether you are managing the risk from trees. And one of the core things we always try to remember is ALARP. So ALARP is keeping things as low as reasonably possible. And if we look at my colleague here, Richard, he's standing in the base of a beech tree. And now at the time, this was still a full tree. It was up probably 80 feet above him. He's standing in a failed fork union, and I'm standing on the other part of the tree, which was equally as big. And at the time, we thought this would be a great photograph just to show, you know, the difference between the small tree in the centre of London and a large tree in the edge of a woodland. Rich is looking fairly nervous because as he was standing there, he could feel this inclusion behind him flexing and moving in the wind loading above. So the idea is to give a bit of perspective that the hazard and the risk and the likelihood of harm in the previous tree is much different compared to this tree. Although this tree is in the edge of the woodland, not in the centre of London. Yeah, so going back to ALARP, as low as reasonably possible. That's the key phrase. We don't have to manage out every single risk from every single tree. It's just not possible, and it wouldn't be reasonable. And a good way to remember it is that ALARP is not a live action role play, which is what my kids instantly thought of. Goodness knows why. I don't know who this character is, but he could cut down some trees, I suppose. So moving onwards, we go into what are the odds, again, to set the context of risk of death from trees in the UK. So these figures again from HSE, and I think they're in National Tree Safety Group's publications. And normally with people in the room, we'd say like so higher or lower, like you do on the TV shows there. So I didn't realise, but the chances of being killed during the London Marathon are 1 in 72,000. I think if I tried it, I would definitely be the 1 in 72,000 because yeah, my nose runs and that's about it. I haven't got a running bone in my body. So then the risk of being killed by lightning. Normally we'd go higher or lower here. And you may not be surprised to realize that there's a 1 in 71 million chance of being killed by lightning. So pretty darn remote. Chance of being killed in a workplace accident? I think probably less than 71 million, and you'd be right. So it's 1 in 200,000 chance of being killed in the UK in a workplace accident. And then finally, falling trees and black branches. So it's not clear from the data I had whether this included those in industry as well. So tree surgeons, foresters, those kinds of people. But we'll work with what we've got, and Sue James might be able to help out with that. Falling trees and branches, a chance of being killed by those is 1 in 15 million in the UK. And this data set was taken from 97 to 2002, at which point there was an average of 4.5 people died annually from falling trees and branches in the UK during that time period, which is, a lot. If that was somebody in your family, obviously it's going to be a horrible, horrible thing. And when you consider in 2022, the population of the UK was 61,600,000. So to only have 4.5 people killed on average in that year, it's a low amount, really. The likelihood of you being killed by a tree is vanishingly low. So you might say, well, why do we bother? Why do we spend all of this time and money assessing the risk of trees and managing the risk from trees? Well, there's several things, really. And this is the bit where I either lose people in the talk or I gain people in the talk. So this is a oak tree lying across a rental car. And I should say, first and foremost, both occupants got out with scratches and bruises and a rather surprised look on their face. This was quite some time ago now. This was about 2013. And to give you an idea of what's going on here, this piece here is the stem of the tree. And this piece here is the branch of the tree. So this was a tree along the side of a trunk road in South Wales. And the car had been waiting at traffic lights, decided that it didn't want to wait at traffic lights anymore, snuck through, and as it snuck through, the tree came over, and this is the result you see now. Horrible. This is what we want to avoid. The key point to remember is that this tree was surveyed by an expert. So that I surveyed this tree. This was one of my jobs. I'm a suitably qualified and experienced person. I hold a professional tree inspection certificate. I've got a whole bunch of trade qualifications coming out my ears. We had a robust methodology, we had a robust scope, we had a robust method of recording our data and plotting our trees and evidencing everything that we did. At the time of inspection, there was no obvious sign of significant defect found in this tree. There was no fungal fruiting bodies, there was no cracks or splits or hollows. The tree had a apparently relatively normal canopy to it. So much so that we didn't even record this tree. We were recording by exception only at the time. So we were just capturing trees that needed some work done to them or needed further inspection to understand what was going on at the time. And as this gave us no indication that there was something suspicious going on with it, we didn't record it. Did make note in my diary that day, my work diary, of the mileage that we did. So we did between this point and this point on the route, so I could demonstrate exactly when I was there looking at that tree. And what transpired was that the third-party landowner had their ARB inspect it. I went out and inspected it as well, and we came to the same conclusion that the main causal agent of the tree falling over was a fungi that is not known to reliably fruit. It doesn't always show itself. When it does show itself, it's not persistent. It doesn't stay there for very long at all, and it doesn't give crown symptoms, and it affects the main rooting structure of the tree. It sort of envelops the roots and causes a loss of integrity at the roots, so that they're without excavating the root plate and taking samples, there was no way that I would be able to determine that this fungi was present in the tree. And as you say, that is not a reasonable approach to take for every single tree alongside a trunk road agent. So yeah, the message is you can do everything within your power to take a reasonable and proportionate approach to tree hazard management, but trees can still fall over. Just because you wear your high-vis vest while you're riding your bike to work, it doesn't give you a shield of invincibility. You still may come to harm. So we must remember that trees do fall apart. Trees do break, and they do have hollows and cracks and splits and problems to them. But there's generally only a problem if there is a target for the tree to hit. We often hear tree professionals explaining that if there's no target, there's no problem. If it's going to fall over, and in the case of the whole tree here on the right-hand side, it's just going to land on crop, don't worry about it. Or this willow on the left-hand side, it's just going to fall over, land in the nettles, maybe scare a few sheep, don't worry about it. And that the benefits that these trees provide are enormous. So moving swiftly onwards into how do we manage this? So there are several methods for managing the risks from trees, and they pivot around normally around a visual tree inspection by a suitably qualified and experienced person. You'll hear reference to a number of different systems. There's a quantified tree risk assessment, QTRA, there's VALID, there's Tempo, there's threats, there's a whole bunch of different things. And essentially they're doing a very similar thing in a very similar way. They're recording what is the tree, where is the tree, how big is the tree, what's it going to do if it goes wrong, basically. And they all feed into an ISO 31000 compliant risk assessment management system, which is many local authorities will have it, many large organizations will have it as well, or at least you should. God, these buttons are slow, sorry about this. So the first steps, if you're a local authority, if you're taking on a large estate, then you absolutely must need to allocate appropriate resource to manage trees proactively. I know that there are some tree officers who have since retired who have taken the view on some significant A roads in South Wales that the amount of impact to their budget, their resource and disturbance to the use of that highway far outweighs the likelihood of a tree falling on it. And yeah, thank goodness nothing happened on that roadway, but I've often pondered what the legal position would be on that if it did happen. It'd be an interesting one for Sarah and the others to pick up on maybe. But yes, please don't ignore trees, allocate appropriate resource. You need to agree a plan of action, at the very least, ideally set out a policy or strategy. So may be familiar, there was a case a few years back with a wildlife park down in South Wales where unfortunately somebody was injured by a falling tree, and in that case it was found that the landowner, not only did they not have a robust system in place, but they weren't found, the judge said something along the lines of that he didn't believe that the landowner intended to do anything, that he had no system for recording the trees, he had no policy, he didn't show anything in his arrangement of that wildlife park that he cared about it, that he took on appropriate accountability for it. And to the judge at the time, that was as much of a problem as the incident itself. And then confirm how you're going to prioritize your land holdings. You know, it's very straightforward to go out and say, right, we'll survey the lot, and you'll very quickly run out of time and money. It'll be like painting the Forth Road Bridge. You may never get to the end of it. And of course, engage with existing staff to undertake passive assessments. So passive assessments is something that large landowners often use. National Trust are great at doing it. And what it basically means is, after a storm event or a significant weather event, you don't necessarily need to phone up a tree professional like myself. You could just have, I don't know, the manager of the tea room could do a quick walk around the orchard and just see if anything has changed. You know, is there a tree at a jaunty angle? Is there a branch hanging off? That kind of thing. Those kinds of passive assessments can really help lower the likelihood of a problem, because they're obvious problems. You can spot them easily, you can tape off that area, you can remove the public from that area. It's an easy solution. And then employ a suitably qualified, experienced person. There's lots of us around. You can find us through the Arboricultural Association. You can speak to your local authority. They'll have people that can recommend good people in your area. And you can refer to guidance notes such as the National Tree Safety Group. Very good document, Common Sense Risk Management of Trees. I really like this. We've used it a lot in our practice, and then also we use valid tree risk assessment in our practice. Like I say, you don't have to use that. There's a whole bunch of other ones. We use valid, and it sets out the basics of a tree policy and a management strategy to help you along your way with managing those things. So you've decided trees are good. You're not going to cut them down just willy-nilly. Trees are very rarely dangerous, but they can be. And you've decided that you do need to engage somebody. So the next steps generally are zoning. So rather than go out and survey, as I say, your entire estate, you may want to do some work using very simple GIS tools. And as I touched on earlier, if there's no target, there's no problem. So these are some map extracts. Let's see now. This one on the right-hand side is Cardiff. And basically, this is zoned based on the height and size of the tree in response to, or in relation rather, into the houses and roads next to it. So red, basically, it's a heat map. So red are your biggest trees that are closest to something that it's going to hit. Yellow, less so. Green, less so. And then likewise, this green square over here, this is a survey from the Gwent levels. And basically, the light green is anything that's under 3 meters tall. The dark green is between 5 and 3 meters, and the white is any vegetation that's over 5 meters. These are not proprietary things. If you've got GIS people in your team, you'll be able to, or they'll be able to sort this out for you. And it just helps target where you go and start your surveys. Obviously, if you've got trees that are under 3 meters tall, they're probably going to have to be shot from a cannon before they do any great damage, but you know it helps you say, right, let's do the large trees first, then the smaller trees, and then the smallest trees after that. Helps you budget, amongst other things. So then moving on to some examples. So the oak tree on the left, this used to be twice as big as it was. Basically, it had a fungal infection in the fork here. One half dropped out. You might say, well, it's only golfers. If you don't like golfers, you wouldn't worry about it. But you know, this is alongside the green, so that the occupancy rate was quite high here. The image on the right, it's a section of woodland, but it was alongside the Basingstoke Canal. And you think this is a very obvious problem. This is something that your passive assessors could spot easily. So if there was a lock keeper on site, or you know a countryside ranger or whoever it might be riding their bike up and down here, they could close off this section. As it turns out, the canal manager phoned us up on the morning of this and said, oh, we think we've got a bit of a problem. Would you mind going to take a look and just see what you think? And then myself and Reese turn up and think, yes, there is very much a problem there. Yes, let's close the towpath, please. But we'd rather have one phone call like that. We'd rather have 1,000 phone calls where there's no problem at all than not have one phone call like this. It's important. And then likewise, a few more examples. So again, woodland alongside, this was in West Sussex. So this was an A road in West Sussex. I forget which one off the top of my head. But there's quite clearly an ash tree here amongst a woodland edge that has succumbed to ash dieback disease. And you know this poses a threat to the safe use of the road. Quite easy to spot, quite obvious. The one on the right-hand side here, this was alongside the A1 near Newcastle. Again, in a woodland, so set back away from the road slightly, but tall enough that it would impact the barrier and the hard shoulder of the A1 here. So we were carrying out just a walkthrough of the woodland here, trying to spot obvious defects, and then of course came across this problem here. And then unfortunately, between us identifying the tree and the landowner doing something about it, the tree did fail and fall over, and the tips of it did hit the Armco barrier there. Thankfully, nobody hurt involved in there. So just, yeah, gives example of what is it, where is it, how big is it, what's it going to hit if it falls over. Obviously, if this one falls over, it's going to block the road and cause significant harm. this one falls over, the tips, as it did, the tips are just going to hit the Armco, and maybe some splintered bits break into the hard shoulder and lane 1. So then we need to allocate priority based on what we found. So as I say, there are a lot of different systems out there. The system we use provides a simple traffic light system. So basically, you need to do your red ones first, then you do your amber red, then your amber, and then your green. We find that our clients prefer this, and it's simple. It helps you understand where your biggest problems are, where you need to spend your time and your money quite quickly. And then when you do have your detailed tree surveys undertaken, we'll just show these as basic examples. So you should end up receiving something that looks along the lines of this. As I say, this is just a very basic example. This is a Welsh water site where they've also got an education centre in the middle here. So they asked us to go in and have a look. We record by exception, so we only record the things that are a significant problem. You can see even in this relatively wooded area, there's on occasion they'd have 3 coachloads of school kids here at a time doing various forest schools activity through here and around the pond, and then they would go doing riverfly sampling and that kind of stuff in amongst this belt of woodland here. Generally, a lot of the problems that we encountered were hanging branches or squirrel damage or ash dieback. This whole section here was riddled with ash dieback, unfortunately. So nothing immediate where you say, holy smokes, we've got to shut the place down and don't go in there and go forth like an emergency service. It's very rare that we encounter anything like that. And then just to finish off, this is typically what you'd end up seeing as when you receive a tree survey from just about any professional tree inspector. It might vary slightly, but it'll look along these lines. So it'll tell you exactly individual reference number, what is it, how big it is, what's wrong with it, what you need to do with it, and how quickly you need to do it. And in a nutshell, that's pretty much it. It's just a case of taking a balanced and proportionate approach. As you say, there are many great benefits of trees. The potential of being killed or injured by a tree is vanishingly low. Make sure that you've got something in place that demonstrates that you're taking the responsibility appropriately, basically. Hopefully that helps. We could talk for weeks and weeks and weeks about the in-depth detail of tree hazard management and how we understand trees, but for now, at least, that's it from me.
Over to Naomi next.
Hello, Sarah. Can you hear me okay?
I can hear you, Adam. I've stopped sharing the coffee break screen now, so you can pop your slides up if you want
I'll pop them
to
up.
get
Yeah,
ready.
I'll do that.
Maybe wait another couple of moments then until the past.
Yeah, I won't start yet. Don't worry.
Thanks.
Can you just tell me when you can see them, and then I'll.
I can see them. Yeah, not on presentation mode
No,
at
I'll
the
put it
moment.
on. I'll do that now. There we go.
Thanks. Yeah. I'll go silent now, Adam, and turn my camera off. So you just kick off when we
Okay.
hit the past.
Yeah, I'll give it another minute or 2.
Okay, great. Thanks.
Okay, good morning, everybody. My name is Adam and I work for the Woodland Trust, and I'm going to be talking to you for the next 20 minutes or so about heritage trees. So hopefully you all grabbed tea or coffee or beverage of your choice. And I'm going to provide, I think, a bit of a sort of counterpoint to some of the presentations that we've already seen, looking a bit more at some of the sort of public attitudes, thoughts, feelings about trees, and this idea of heritage trees and how we can merge protection of our sort of natural heritage and our cultural heritage within this concept. So firstly, a bit about the organisation I work for, the Woodland Trust. We were formed in 1972 to save an area of ancient woodland in South Devon in the Avon Valley, and you can still go there today and see that woodland. Since then, we've acquired lots more woods. We've got about 1,200 now. About 30% of those woods are in urban areas, all freely accessible to the public, and they range from the vast areas of sort of forested landscapes in Scotland to, you know, small pocket-sized woodlands in some cases. I work in our Conservation and External Affairs department, leading our campaigning team, and that involves leading a few programmes of work, including on planning casework on ancient veteran trees and ancient woodland and on urban trees. So we've already had one picture from Windsor, so here's another. That's me on the right. And just to sort of give you a bit of background, I've been working in nature conservation for about the last sort of 15, 16 years, for a long time at the Wildlife Trusts, and then for the last 6 years at the Woodland Trust, on a variety of community engagement projects and public engagement projects, programmes, that kind of thing. The Wildlife Trust have worked on a long-term campaign to secure protection for marine habitats through the Marine and Coastal Access Act. So that was about 9 years of sort of campaigning that eventually got that legislation in 2009, and now that's been enacted through formation of marine conservation zones to protect areas of the seabed. I also set up a campaign called 30 Days Wild that was all about sort of Movember campaign for nature. It's all about public engagement. So I'm really interested in the relationship between people and nature. And I find that trees are just a brilliant way to examine that, which I'm going to talk about now. So that's me. That's my colleague Jack there, and I think Jill possibly behind the tree. So what we'll cover. So what is a heritage tree? Then a bit on the current definitions, protections, conservation of our trees, particularly most oldest and special trees. A bit on the loss and the problems that we're trying to tackle. A bit on the heritage trees, private members bill, and where we might go next. Let's start by thinking about what is a heritage tree. So I'm going to talk about the private members bill in a little bit later in this talk, but this is the definition that we've got in there. It's just a definition in the bill at the moment, but it's looking at those different kinds of values, so historic, landscape, cultural, ecological value, similar to the system in Italy for monumental trees, which has this sort of multiple value kind of idea behind it. But I think it's perhaps easier to just look at heritage tree, a really good example of one. And this is the one that comes straight to mind when I think about heritage trees. So it's the Allerton Oak in Calderstones Park in Liverpool. So this is a postcard from, I think, 1847, illustration showing the tree then in the grounds of a manor house. I think it's about 50 years later, the Old Oak in Calderstones Park, and another one, the famous Old Oak. So this is a tree that people have connected with and valued over the centuries. This is a picture I took about 3 or 4 years ago. Just a wonderful tree. I mean, you can see from that, just immensely interesting to look at, fantastic aesthetically as well as ecologically. Great to see an ancient tree like that in a public park. This is me with John Warren, who's looked after this tree for about 50 years, more maybe. Just a fantastic individual and done a massive amount for this tree. So I want to give John a special mention. And then here is a card with a connection to the Allerton Oak that was sent by Liverpool Council to its employees that were serving in the Second World War. So in Christmas 1941, they sent this Christmas card to employees that were serving in Europe, fighting in the war. And it contained a pressed leaf from the oak tree and this poem on the right. I'm just going to read it. So, not all the storms of centuries have bowed the British oak, nor shall the wiles of evil men bring Britain 'neath the yoke. Here in the soil of England I mock the winds that blow. My arms shall wave for freedom when lusting men lie low. So imagine getting that in the trenches in sort of December 1941, sent from your hometown in Liverpool. And I think that just really symbolises everything a tree can be and can mean to people. A very moving story. So let's moving on, because I've got to get through quite a lot in the 20 minutes we've got. So you'll all be familiar with these definitions of categories of trees. So ancient, veteran trees are how we refer, the most commonly used ways of sort of conceptualizing our old and special trees, giving them protection through things like National Planning Policy Framework and other instruments. And obviously different kinds of looking at ancientness. There's developmentally ancient trees, there's chronologically ancient, and big overlap. So let's have a think now take a step back and think about the other things that we protect in Britain and how we protect other bits of sort of culture and nature. So we protect species, wildlife, through a variety of bits of legislation. Probably the heart of that is the Wildlife and Countryside Act, and then the European protections, where we list species that we want to protect, things like the curlew. And we protect sites, we protect triple SIs and European protected sites. And again, we list those sites, and so we know which ones we're protecting. And with triple SIs, it's about representative sample of habitats. We give those legal protection. Protect buildings, so listed buildings. I can't remember which building this is. I think it's really cool. I must say the point of this talk is not to say, why can't we protect trees? Because we protect buildings. I think it's really important to kind of protect all this heritage. And I'm nearly as into listed buildings as I am into ancient trees. So we also protect shipwrecks. So the Protection of Wrecks Act, I think it's about 1973, protects just over 50 shipwrecks around England. We have scheduled monuments. Again, a schedule that says which monuments we're trying to protect, gives them legal protection. Registered battlefields, I think that's the Battle of Bosworth. Registered parks and gardens. And interestingly, this is a new one, which is an inventory of living heritage. So a couple of years ago, the UK ratified a global treaty, a UNESCO one, on the protection of intangible cultural assets, which means that there's just been a consultation on protection of developing an inventory for protection of cultural heritage. So things like folklore traditions, like the cheese rolling in Gloucestershire in the photograph there. Interesting concept, that living heritage, one that you could argue might apply to trees, but I think trees are not really considered in the scope of that. I think perhaps that's the point of this slide, really. It's that trees sort of fall between the gaps they fit into many of these categories, arguably, but fall between the cracks of all of them at the moment in terms of having a systematic protection system that ensures the conservation and stewardship of that really important heritage and ecological assets. And ancient veteran trees, I think a lot of this comes down to definitions and categories. So ancient veteran trees, it's a sort of feature-led definition. Ancientness is relative to other species of relative to the species. So it requires an expert assessment, really, to decide if a tree is ancient or not. Woodland Trust runs the Ancient Tree Inventory. I'm sure lots of you are familiar with that. That has around 200,000 trees on there. About 10% of those are verified ancient trees, where an ancient ATI verifier has gone out and verified it as an ancient tree. But the other things that we were just looking at on the previous slide are all kept in lists, schedules and registers, which means there's a sort of black and white definition, really. It's either in the list or the schedule or the register, or it isn't. And if it is, then it gets legal protection. And I think that's sort of part of the idea behind this idea of heritage trees. It would enable us to apply the same approach that we take to protecting other important cultural heritage to some of our most important trees. Not all of them by a long way, but some of them. And of course, you have tree preservation orders, and I'm not really going to talk very much about that because that's already been covered. Sarah's great presentation at the start. I think it's quite interesting photographs. I took this at the Whitewebs Oak, which was the ancient oak tree that was, majority of which was cut in April, big public outcry, and the tree officer very sensibly served a tree preservation order on the remains. That's the piece of paper you can see on the bottom of the trunk there. But just to make the point that yes, tree preservation orders do exist, and alongside things like felling licenses, they do give that protection to trees, but in response generally to threats rather than a strategic assessment of holding on to that heritage and ensuring it's there for future generations. So this idea of cultural heritage, here's the definition I think that Historic England uses. It's about that inheritance from previous generations and seeing ourselves, I suppose, as holding that for a while and then passing it on. So I just want to show you 2 slides now, looking at that data from the Ancient Tree Inventory that I mentioned before. So what you've got here is data on 200,000 trees and the forms of those trees and how those forms correspond basically to age, notable, veteran, ancient. It's a really interesting pattern here, looking at the number of ancient trees that have had some form of traditional management. And I think this slide really shows you that link between the sort of human care and intervention and management of trees and their longevity. Perhaps here's a way of visualizing that. So this is the Queen Mary Psalter, I think. So it's a picture from about 1310 of a swineherd disturbing acorns from a tree. So, that drawing's what's over 700 years old, amazing. But just showing you that, we've had these forms of sort of tree care and management around for a very, very long time. So I think it's fair to think about conservation of trees as conservation of cultural heritage as well as natural heritage. So now just a quick slide thinking about how law can help and what we're trying to do through law. So obviously law can stop, prevent bad things happening, punish, set out punishments, penalties. But there's this idea about the expressive function of law, which is about, as it says on this slide, creation and validation of social norms. So if we think back to that slide with the shipwrecks on, that's kind of that the sort of heritage law underpinning that is setting a social norm that you wouldn't go and disturb a shipwreck, that these are sort of have some sort of element of sanctity, I guess you might say, and therefore they need to be protected. And I think that's part of what could be achieved through protecting some of our oldest and special trees in law. It kind of sends a statement out that these trees are as important as those other parts of our sort of natural heritage. Equivalency, really. So why would we want to do all of this? So is this heritage at risk? Well, the honest answer is it's really hard to know. We obviously have the Ancient Tree Inventory, but there's not a sort of systematic analysis and monitoring at a population level of our oldest trees to know how many of them are in decline, what are the sort of trends affecting them. There's obviously an awful lot of knowledge held at the individual site level. We've mentioned sites like Sherwood Forest, which have been really well studied, well looked after. But at that kind of national population level, it's impossible to know, really. So for built heritage, we do this. There's the Buildings at Risk Register. So here's an example of one of those. And the text here just shows you what happens, really, when we're keeping an eye on these things. So we put in place plans for repair and restoration. There's advice and guidance, bringing things back into community use. So I think those are all ideas that you can sort of hold in mind, thinking about what's possible for trees as well. So we have been doing a bit of work with our friends at the Tree Council. So John Stokes from Tree Council wrote a series of books. Some of you might have read these on heritage trees, different countries around the UK. So we've been running a project with a Tree Council that's involved going back to look at 200 of these trees and what's the changes have been in the intervening 20 years as a sort of cohort of trees. And that work's going to be, I think, published in a few months' time. Just to give you a little sort of preview of that. So we were looking at the kind of secure, threatened, critical, or lost status of those trees. And sort of roughly a third were threatened or critical. And there are sort of conversations going on with the managers of these trees to help provide advice. And these are the sorts of things that are threatening them. Again, it'd be familiar to many of you. And what you're seeing here is a reflection of threats that are in sort of wider landscape, agricultural, countryside settings, as well as urban planning and development scenarios. And there is a kind of perhaps a longer term trend of loss of large trees. Again, we don't really have a kind of national picture of this, Woodland Trust ran a study a few years ago using the First Epoch Ordnance Survey maps, looking at an area of East Anglia. And we were looking back at those maps from 1840 and 50, where we drew on, where there were individual trees were drawn on. So you can see that in those windows there, A, B, and C. We were looking at boundary trees, scattered trees, so often infield trees, and then groups of trees. And we found that the scattered trees in particular, we lost 85% of infield and scattered trees in this area of East Anglia. It was the area that Constable did a lot of painting in, hence that's why the picture's there. So yes, Dutch elm disease will have accounted for a lot of that loss, but not all of it. And to synthesize all that into a kind of headline finding, basically about half the large trees in the landscape had been lost in the intervening 150 years. Not every important tree is in a safe place. And just to give you a few examples of those sort of culturally, those heritage trees. So Woodland Trust is running our annual Tree of the Year competition at the moment. So just picked out 3 examples to show you, because it's just nice to look at some pictures of interesting trees sometimes, isn't it? So these are the Borrowdale yews, very ancient yew trees. There were 4, now it's down to 3. Someone in this conference may have the detail on this, but my understanding is that DNA tests have shown it's actually genetically one tree. So it's probably been yew trees on that spot for an immensely long period of time, sort of high up in the hills in the Lake District. And I guess the three trees that we're looking at now may have come from one original tree. And the mind boggles us to kind of thinking how far back that might be. So one for the music fans here, this is the King of Limbs in Savernake Forest in Wiltshire. So King of Limbs is the name of an album by the popular band Radiohead, and that was where the kind of name came from. So they named the album after this fantastic oak tree in Savernake. You can see why it's called the King of Limbs. And then finally, the Argyle Street ash, so nominated by David Trina from Glasgow City Council, who's been doing a fantastic job of advocating for this tree. I think this was the first tree in Glasgow to be protected with a TPO. There are some really nice old black and white photographs of this tree. Oh, there's one, yeah. And yeah, we all know about the Sycamore Gap tree. So what next on the Heritage Trees Bill? It's the final part of the talk. So we've been working on this idea of how could you turn this idea of heritage trees into an actual piece of legislation. So there is a draft Heritage Trees Bill that was proposed by the Woodland Trust previous chair, Baroness Young, in 2023. It's had its first reading, but not gone further than that. I'll pop a link to it in the chat after I finish the talk. And it's quite simple framework legislation. It was drafted by the Bills Office in the House of Parliament, and it's about defining heritage trees, creating a national list, and then using a heritage tree preservation order to sort of proactively protect the trees on that list. And the advice we had from the Bills Office was don't invent something new, just sort of augment or amend something that exists. Hence that proposal for a heritage TPO, which would be a sort of proactive conservation tool. You can read the bill itself is very short, it's about 5 pages long. I'll pop it in the chat at the end of this talk. And here we are, we took a petition to Downing Street last year with the Tree Council there and some MPs. And that's Charlie from our youth council holding the box in the middle to it. Over 100,000 signatures for that petition. And the Sycamore Gap, and that sort of coincided with the production of this report, which was commissioned after the Sycamore Gap felling, produced by Tree Council and Forest Research about protecting trees of high social, cultural, environmental value. Identified a number of areas for attention, including gaps in the legal system, some of which I've just been talking about. And as the Tree Council website says, government's currently considering what to do about that. So just to finish then, it's my last slide. We went to Poland, took a study tour to Poland 2 years ago to look at their Green Monument Scheme. So this protects around 30,000 ancient veteran trees across Poland. They go on a national list. Local councils can then access small grants to help with kind of bits of arboriculture. It's also about celebrating them and championing them. That picture on the left shows Piotr, one of the arborists who showed us around, with Miśko, which is an ancient oak tree. I think it might be the oldest oak tree, certainly in Warsaw. That's a picture of Warsaw out there. the council office window there, and you can see 3D printed this oak tree, and we were sort of having a conversation about conservation of that tree. And here we are underneath the poplar tree with some of the people from Walsall City Council that kind of administers the list and that protection system within Walsall. So an example of some of the things I'm talking about in practice. And I think that's it, Sarah. So all done, and I'll pop a couple of links in the chat. So I hope you found that interesting.
Thank you so much, Adam. That was absolutely fantastic. Thank you. I'm sure everyone agreed that there were lots of thumbs up and hearts and smiley faces, in particular when you read out that poem. That was incredibly moving. So thank you for doing that. I'm taking us back to the black letter law now, so it's a little bit more the nuts and bolts in terms of law, and I'm talking about a politically hot topic, which is TPO compensation claims. Can I ask you guys to give me a thumbs up just to check that you can hear me and see my slides? Yeah. Excellent. Oh, fab. Excellent. Thanks, everyone. Right, so TPO compensation claims, understanding the risk. So I'm going to talk about quite a common situation. This is where a domestic property suffers from subsidence damage. So I'm pretty sure all of you guys will know what subsidence damage is. In a nutshell, it's when a property suffers from crack damage as a result from roots from a tree encroaching underneath the property's foundation. That property is built on a shrinkable soil. As the roots remove moisture from the soil to transpire in the summer, that soil shrinks, the property moves downwards, down in the summer, up in the winter. So in this scenario, we've got a domestic property suffering from subsidence damage. We've got investigations that show a cyclical pattern of movement. So as I've said, that down in the summer, up in the winter, which is indicative of vegetation-induced damage. An assessment of nearby vegetation highlights that a TPO protected tree is implicated in the damage. Roots from the TPO protected tree are recovered from the soil underneath the foundations, and an engineering assessment concludes that tree removal will stop ongoing movement of the property, allowing the property to be repaired with just cosmetic repairs. The tree is owned by the householder, but no action can be taken by them because it's protected by a TPO. So an application is made to the planning authority for permission to fell. I can almost feel sort of a gasp amongst everyone. I'm sure lots of you will have come in contact with these sorts of scenarios where you've got an application to fell a TPO protected tree where it's implicated in damage. So the application itself, an application alleging structural damage caused by a TPO protected tree, has to be accompanied by a high level of evidence. Once made, the application will be validated by the planning authority to confirm that all required evidence has been submitted, and then the planning authority have got 8 weeks to review that and provide a decision. So the planning authority's decision could either be a notice of approval, possibly with conditions, and if there is an approval, usually giving a deadline of 2 years within which the tree work can be carried out. Alternatively, a notice of refusal, rejecting the application to carry out the work to the protected tree. Now, I hear people referring to an application to remove the tree preservation order. It's not that. It's not an application to remove the TPO. The TPO stays there. A tree preservation order is a land charge. It's an application for permission to do work to a tree protected by a tree preservation order. Semantics, possibly, but the TPO stays there in the background. So the notice of refusal. If a notice of refusal is issued in response to this application, then this opens up the planning authority to a possible claim for compensation. So this is the legal claim which could follow a TPO application. Now, this isn't a civil claim like a claim for damages if it was a council street tree causing damage to an individual's property. So this is a claim for compensation. And again, it sounds like semantics, but it's different. So this claim is pursuant to section 202E of the Town and Country Planning Act and in England Regulation 24 of the Town and Country Plan and Tree Preservation England Regulations 2012. So it's very statute based. This isn't a claim in nuisance and negligence. This is a statutory claim. So in Wales, it's slightly different. It relates to the Town and Country Plan and Trees regulations. As we know from my talk earlier on, the law around TPOs in Wales and England is slightly different. So what this claim does is it allows for a compensation payment to be made for loss or damage incurred or in consequence of the refusal of any consent required under the regulations or the grant of any consent subject to conditions. So what this does is it puts the local planning authority under pressure. So if they want to issue a notice of refusal because they want to stop any work being done to a TPO protected tree, then they are immediately on risk of a possible claim for compensation. So what does this claim look like? How much is this claim going to be for? So to work out how much compensation can be claimed, it's different from the scenario in which it might be the council's own tree that's caused or implicated in damage to a property. So here you look at the loss of what is the loss and damage that's the natural and probable consequence of the LPA's decision. So actually, if you're looking at repair work, so subsidence repair works carried out to a property, if the council were the tree owner and this was a street tree, the value of the claim for damages would include everything. So it would include investigation costs, it may include underpinning, it will include crack repair works, it will include alternative accommodation, possibly storage costs, drain repairs, it will include sort of the whole gambit. But a compensation claim is different. So the compensation that can be claimed is only the amount of money that had to be spent as a result of the refusal. So, for example, if it's money that would have been spent whether the tree stayed or whether the tree was felled, so investigations, crack repair work, all of that can't be included because that money was going to be spent anyway. The compensation is only for what was spent as a result of the refusal. Also, it has to have been in the contemplation of the local planning authority in refusing consent that this work would be required. So, for example, the planning authority needs to be told that if the TPO, if the tree can't be removed or if work to the tree can't go ahead, then X, Y, Z would have to happen, such as pile draft underpinning, root barrier, some alternative. The loss can't be too remote, so that's sort of remoteness as a legal principle, and it has to be capable of being quantified in money terms. So what that means in broad terms, then it's a bit legal above, is if the refusal means the property has to be underpinned to stabilise it from continued movement in the presence of the tree, the claim for compensation is broadly going to be the cost of the underpinning work. Compensation claims are different from claims for damages. So these aren't claims that are brought before the civil court. These are claims brought to the upper tribunal of the Lands Chamber. So in fact, when you go through one of these claims, they look very similar. The steps are very similar. What you have to do is very similar. The courtroom is very similar. It's often in the same building. The judge is very similar. It's often the same judge. But it is different. So a compensation claim is brought before the upper tribunal of the Lands Chamber. As I said, it's a claim for compensation, not legal damages. And the claim, as I said, is not the full amount of the money spent in investigating and repairing the house. It's for the amount spent as a result of the refusal only. So even if you win, there's not an... Oh, talking about compensation claims, so even if you win at trial, there's not an automatic entitlement to the recovery of your legal costs. So that's where it can differ from those claims for damages. So this is an extra factor that can make these even more risky, even more financially risky for all parties concerned, because these claims do cause significant, I would say significant stress due to the potential financial risk at stake. So one of the last reported compensation claims at the Lands Tribunal was the Chubb versus Enfield case, which was back in 2024. You guys may well be aware of this and have heard of this. And actually, there aren't a huge number of reported cases. I think if you look at the Lands Tribunal past decisions, there's about 10 or 12 of them. So there's really not that many. It's different from the case law that we see in the civil cases. So in the Chubb and Enfield case, the property suffered cracking in 2014 due to subsidence, which was thought to be caused by the roots of a TPO protected tree. 3 applications had been made and 3 refusals had been granted. So 3 refusals for permission to fell. So that notice of refusal had been issued. And as a result, the claimant underpinned the property at the cost of £143,000. So the claimant then sought compensation of that £143,000 from Enfield. In that case, the tribunal dismissed the claim, ruling that the claimant had failed to prove on the balance of probabilities that the tree was the cause of the subsidence. There was no evidence of severe desiccation in the subsoil. Seasonal movement patterns, so that up and down movement that you expect to see with vegetation-induced subsidence, so that was inconclusive. And the roots that have been recovered from underneath the foundations of the property, the identified roots may well have come from another tree. So the tribunal observed that there were other possible causes. So on that claim, that failed on causation. No other legal arguments need to be considered in that claim. So it was just a pure, there wasn't enough evidence to show that the tree actually was the cause of the damage. So why do these cases cause so much concern? I mean, this is such a huge hot topic, TPO protected trees involved in claims such as subsidence claims. Well, I think one of them is that local planning authorities have no insurance to protect a liability for compensation. So if you had a local authority owned street tree and there was a claim against the damages, in the vast majority of cases, the local authority's insurance company would step in and would manage that liability. But in these cases, because it's a claim for planning compensation, there is no insurance cover. So what that means is the planning authorities, if they face this risk, and there is a financial risk, they have to find that money from within their already stretched budgets. So this can leave planning authorities feeling that they have no other option but to grant consent to allow for tree work, because they simply can't face the risk, or they can't risk, facing a compensation claim. Obviously, this compensation claim only arises if there is a notice of refusal. So they can feel pushed into having to give that notice of consent to avoid the risk of a compensation claim. So they feel pushed into granting that permission to fell the exact same trees that they deem to be of high enough amenity value to protect with a TPO. So what can be done to help in these cases? There's a lot to talk about. We need to change the law and bring about change, which means that planning authorities can confidently issue those notices of refusals without facing the risk of a compensation claim afterwards. Some of you might recall Article 5 certificates. So these were an old article which went with older TPOs, where actually if a tree was deemed of such high amenity value, the local planning authority were able to apply a certificate, meaning they were exempt from a compensation claim in relation to that particular TPO and that tree. So looking at that, you can see those no longer exist in England. They were abolished in 2012. They never existed in Scotland, and some of them are still existing in Wales, but only relating to those older, rare, historic TPOs. So there's a big call in the industry as to whether reinstating these Article 5 certificates would be a way forward and a way to help protect these TPO protected trees, and allow the planning authorities the confidence to issue those notices of refusals. So what are the options? as I've said then, the campaign for the returning of the Article 5 certificates, but I think there are other options that are being discussed across the industry. The first one I've put here is upskilling planning authorities to understand the level of risk. I speak to a lot of planning authorities who feel that they are presented with a fait accompli and they've had correspondence from a claimant who is telling them exactly how risky it is, how high the risk is, how much it's going to cost, and sends them into a panic. I would observe that a claimant will always tell you confidently that their claim is strong and that the risk that a defendant faces is high. But I've got to question, is it always going to be a high risk in all of these cases? These compensation claims, subsidence damage, evidence, how much that you can claim in a compensation claim, it's a tricky area and it's a highly skilled area. So I think perhaps upskilling planning authorities to really understand what that risk is and what it looks like into the future could help give some confidence to issue some notice of refusals, being confident in their prospects of success, even if a compensation claim were to follow. So the second one there is the campaign for the return of the Article 5 certificates. I'm not sure what you guys think about that, but that's a potential option. Number 3, urge home insurers to either forego pursuing compensation claims or avoid making TPO applications on subsidence cases involving protected trees. I speak to a lot of people that ask for data about this. So I've spoken to the press a lot about this because it does get press attention. And a lot of times I'm asked the question, how many TPO protected trees are felled in the UK as a result of subsidence damage on an annual basis? I don't know the answer to that, and my observation is that there's probably nobody knows the answer to that, because even if you ask the planning authorities how many of these applications do you grant an approval for on an annual basis, that doesn't necessarily translate into that's the work that will go ahead. The planning authority is the planning authority. We then don't know what the tree owner themselves are going to do in light of that permission or not. If the tree owner is somebody entirely different, regardless of the planning authority's consent, they may continue and give and say no. So it's very difficult to come out with a number. But my observation is, across the number of subsidence claims in the UK, that actually in terms of the number of TPO trees that are implicated in these subsidence claims, that's probably a very small number and a very small percentage of a home insurer's total claims. So actually the financial value of what would be lost if those claims weren't pursued, bearing in mind what I said earlier, which is they're only a fraction of the value of claims for damages, it might not actually be that significant. Number 4, a protocol on the agreed use of the nuisance exemption to the TPOs. This is a contentious topic, but it arises from, as I've said, the nuisance exemption for TPO. So if a TPO protected tree is found to be causing a legal nuisance, then there's an exemption that the protection no longer exists and works the tree can go ahead. In reality, like a lot of the TPO exemptions, it isn't robustly exercised. I think given that a sanction for doing work outside of permission for a TPO is criminal, it can be a very robust step to rely on an exemption, and especially to rely on an exemption which is wholly reliant on a finding of nuisance. So if we rewind back to that Chubb and Enfield case, Chubb were talking about the tree being a legal nuisance. They made the application, they submitted the evidence. But the outcome of the Lands Tribunal is that the evidence actually doesn't show a causal link between that tree and the damage. So therefore, at the very heart of it, that nuisance hasn't been proven. So I think my opinion is that until a nuisance is deemed a nuisance by the court, by a judge, it's only until that point an arguable nuisance, and it would be a very robust step to rely on that as an exemption. Another nuance here as well is legal nuisances require a boundary line. So it's where roots or branches might encroach over a boundary from the tree owner's land to the damaged property land. But that's not always the case in these scenarios. It could be the homeowner's own tree that's causing the damage, in which case you can't cause a legal nuisance to yourself because there's no boundary and no encroachment. So in that case, this sort of ability to tap into nuisance falls away. Number 5, sorry, have an open discussion with the planning authority to see if a compromise solution can be reached. Creative, innovative compromise solutions are out there, and there are people that are willing to have these discussions if they can be correctly facilitated. And I've been involved in a few great discussions which reach a very creative conclusion, which all parties can walk away happy with. So that is that's something that I would really champion, so those open discussions. And then finally, number 6, so these cases grab the headlines. They can get massive negative press attention. There is a space here for people who want to choose to do this a new way and to start changing the negative narrative. So those are just finishing off with a couple of examples of things that have hit the press. So we've got Dean Scopes there, who campaigned against the felling of oak trees in Fareham and successfully got those protected. We've got a Peterborough oak tree, which was an unusual one in that it was a TPO protected tree that was actually owned by the local authority as well. So that was an unusual scenario. And then more recently, down in Exmouth, when the planning authority there gave a notice of refusal. So yet to see what will happen in terms of a compensation claim there. Hopefully, absolutely nothing. So that's it for compensation claims. I could see the chat pinging on my other screen as I was talking through that. So I'm sure there are going to be lots of really interesting questions about that, which I look forward to answering. So if we can go into the Q&A now. So guys, if the speakers want to put their cameras on so we can field the questions. Sue James, very kindly, Sue James of TDAG is going to host the Q&A. So over to you, Sue.
Oh, wow. Is everybody's head sort of spinning as much as mine is? So many things coming through the chat. So I've been busy trying to think, what are some of the critical things that people have raised and want to explore further? I think, Sarah, your last talk actually answered quite a number of opportunities for how we could deal with TPOs. But one really interesting thing came early on from Chris Hudson. Is there a case for reform to include formal sentencing guidelines for TPO prosecutions, so people might have some advanced knowledge that if they pursue that course, the potential risk of, financial risk they face if they aren't successful?
That's a great question. I saw that one coming into the chat. Yeah, that is a great suggestion. So with other crimes, there are sentencing guidelines, roughly what a fine might be or roughly what a custodial sentence might be, but that doesn't really exist for TPOs. And now since the changes that you can receive a limitless fine for breaching for illegally felling a TPO protected tree. But yes, I agree that sort of structure would be useful as a deterrent and a guideline. I'm not sure how those sorts of changes are campaigned for, so I'll have to look that up.
So that was one aspect. Then a whole lot of things have come around, as we know, from TDAG seminars and all sorts of things, and going back and forth on TPOs. Somebody, I'm sorry, I've lost track of who it exactly was, said, should we include historical, ecological, cultural attributes as part of the benefits of giving a TPO to a tree?
Adam, that might be one for you if you can answer that.
Yeah, I mean, that would be another way of effectively approaching what I set out in my talk. So, you could do that by changing the scope for TPOs so they became more sort of proactive instruments that we use strategically. Yeah, and that's something we've actually advocated for quite a long time. At the moment, we're advancing this idea of the bill, but it could be done that way too.
So one of the other things, I think it was Nola O'Donnell who said, should we revoke S202E? Can you explain what that is?
Yes, me.
I think so.
Yeah, section 202E, so the ability to claim compensation at all. That's another option. So that would do the same thing. Well, it would do a wider thing than reintroducing the Article 5 certificates, wouldn't it? Because it would remove the power to be able to claim compensation at all. And actually, I did a bit of research before I prepared my notes, because I know this is such a hot topic. I wanted to be really careful about what I was saying. And I think this ability to claim compensation at all is a little bit of a peculiarity in planning law across the board. And it's a peculiarity that seems to have remained in these tree-based claims. I reached no conclusions as to that, but I just wonder whether perhaps that is on the horizon at some point, and that peculiarity will get questioned more and more. So yeah, perhaps that's a good point.
And then looking at the risk discussion, so I've got things flashing and trying to see what else. If you see anything coming in, new speakers, just sort of say, hey, we need to look at this one. But on the risk discussion, so Peter Simpson made a very good point. Chris Hudson, that there may not be a huge risk from trees in the fullness of other risks and other causes of death and so on, and injury. But whenever it happens, there's a huge uproar in the press, as various of your slides have shown. So how do we counteract that? How do we actually, does there need to be a huge campaign? I mean, how does one counteract the fact that the response to the risk is out of all proportion with the actual risk?
Well, I'll give it a go. Yeah, I think, as somebody else has said in the chat there, it's all about education. I think it's down to us in the industry to lead the way and try and share our knowledge as much as we can with those outside of the industry. That's got to be first and foremost. How we do that is a very good question. I know the Arboricultural Association runs an ambassador scheme for exactly that kind of thing. TDAG for years have been a wonderful resource for promoting trees and good management of trees. I know as long as I've been studying, I've been pinching bits out of their documents. So yeah, long may that continue. Sue, is there anything you would add yourself?
Me?
Yes, yeah.
Oh, sorry. Well, I think it's, apart from trying to get a really hot article in the Daily Mail saying that trees are the least risky element in our society, I think it kind of links to another thing that was brought up quite a bit over several issues, which is the whole question of education and making sure that we've got really well-informed insurers, loss adjusters, planning authorities, tree officers, engineers, who understand the role of trees in this broad kind of array of things where trees actually have an influence. And it's that having better informed people at the decision-making stages might actually help, resolve things. I don't know what any of you think there.
Yeah, that education comment really resonates, Sue, because I remember when I was speaking to the press in the aftermath of the Sycamore Gap and questions about, is 4 years, 3 months in prison a just sentence for what happened there. I walked away from that trial feeling that there were no winners. Actually, how do you punish somebody, and is it all about punishment? And then it led me to thinking that I think it's education which has got to be at the core of all of this. So to really educate kids from a young age and about the value of trees. And, it sounds so cheesy and trite, but the value of trees, maintaining trees and living around trees and the importance of them. So actually, mindless crimes don't go ahead because we all value them so highly, rather than punishing people for when they've done something that they shouldn't have done. So that was an interesting point that cropped up from that.
Yeah, that is. I mean, I'm actually on the Adult Advisory Board of Teach the Future, which is a student-led climate action campaign, climate education campaign, and they're trying to get the whole school curriculum to recognize climate change and nature as part of every topic. So bringing all these things in at the earlier stages, I think sometimes by the time you get to your professional level, some of your thoughts are already set. Whereas people coming through into the professions with some of these greater understandings would actually be really valuable, to which you can then add your professional knowledge to sort of improve the whole thing, but having that right mindset. And then I think that's actually part of counteracting public perceptions of risk and trying to say, but this isn't the case, because they wouldn't be looking to blame trees the whole time, which at the moment is actually the feeling you get that people would like to do. Is that an unfair suggestion? Or, I mean, that people, you know, quite happy to blame the tree as being the problem, whether it's causing the subsidence, whether it's, you know, been the danger in the street, whether the branch has fallen in the park. It's always somehow the tree's fault.
And very emotively either which way as well. So, you know, yeah, some people are. I mean, I remember working as a tree officer, and you turn up and you'd say, "Oh no, we're not doing any works to these trees," and you'd have as many people outraged that you weren't doing work as you were doing works. Yeah, it's often very difficult to understand where people are coming from, because they, of course, have a different perception of the tree than we do. If I take off my Keystone hat for a moment, the other hat that I wear is that I'm chair of the board of trustees for the Arboricultural Association. So I've just put a link in the chat to the website for the Arb Association. Amongst other places, that they have a huge suite of information for professionals and non-professionals. So yeah, if you need some information, head on over there, along with, you know, people like the Woodland Trust and Trees Design Action Group.
Do tree officers need somehow more support? Because somebody's written in one of the things that came up is, you know, very often the tree officer is left trying to make the most appropriate decision. And if they want to retain the tree, then they've got to have the capacity to explain all the reasons why the tree should be retained. Do they need more support out in the field?
I think absolutely. I was a tree officer for several years at a county level, at city level, and for National Park Authority, and without question, they were the most stressful roles I've ever held in this industry, and greatly undervalued by local authorities and the people in those authorities as well. There seemed like days where arboriculture was only about 10% of my role. The other 90% was politics, or highways engineers, or financial controller, all these other things that tree officers have to take into account. I think they're remarkable people that fill these roles, and we should give them every support we can.
And then in this thing, when you were talking about risk assessment, so I'm just converging things together now. And, you know, and I think it was actually, sorry, it was Naomi explaining how you do a proper risk management assessment or approach. And it seemed like a lot of things had to be done in order to achieve it. Well, do tree officers or whoever's trying to manage that actually have the financial or resource capacity to actually carry those things out?
It's a very good question, and it's one that I do when I speak to local authorities. It is a challenge, and obviously we saw that coming up in the word cloud as well. The financial side of things, but that's why I try to encourage those tree strategies to have a a documented approach, but one that is supported by the senior leaders within the organisation, and that's the key bit. You've just said, is there not, there's not enough support for tree officers, and that's because very often that bit at the top is that's missing, that support. So identifying those internal as well as the external stakeholders, and getting their buy-in into your strategy has got to be a key thing. I know it's really hard to do. And one of the things that I've done with a couple of organisations is to work with their tree teams or their, perhaps their insurance officers and those people that are sort of involved in that, to help them to establish that tree policy or strategy. And I've also spoken at risk management groups, things like that, to try and get the message out to the people that can make those decisions and provide those resources.
Sorry, jumping all over the place. One of the things that's been confusing quite a few people is that as sort of tree advocates, we endlessly report and I'm trying to remember where the original research came from, but the presence of trees actually increases property values by 15% or something. So we're now, there's a bit of confusion about in the Newport case, the loss of the tree actually increased the property value. And yet in theory, it was part of it, there were 8 trees, there's a tree-lined street. And of course, everybody says, oh, tree-lined street, better property values. But no, the judge said, got rid of the tree, property value's gone up.
Yeah, that's a really interesting point. So it is, the property itself is in a very leafy area of Newport, and there's not many leafy areas in Newport, but that one was. It's very close to a conservation area. No, not a conservation area, but yeah. Oh, yeah. It is in a very leafy area of Newport. I think it's not a one-size-fits-all approach, and I think because of the location of the property and the fact that the tree was I was going to say in the way of the view, but the tree was the view. I think removing that, the RIC surveyor reached the opinion that it could, on the open market, have increased the value of the property for both the view and also the development potential. But yeah, but it's like with anything in these tree cases, it's not a one-size-fits-all approach.
And one decision can influence the next decision. So Newport's going to influence a lot of decisions, isn't it, going forward?
It is, yeah. I decided to ask ChatGPT what was the highest amount of highest fine that had been awarded in a TPO prosecution case, just to see whether there was any sort of, what was out there. And ChatGPT told me about that case, which I was like, oh yeah. So I was delighted to see that, possibly because I'd already been telling it about the Newport case. But yeah, I was interested to see that.
I see somebody just flashed up, said actually most surveyors don't even notice the trees when they're valuing property. So that was so the last one, because you want to wrap up, is the whole question of tree risk, part of tree surveys and to the extent to which tree risk should be included in the BS 5837 survey. So I'll declare that I'm on the BS 5837 review and the B213 committee, and there's a lot going on there. So I think I'm allowed to say it's likely to come out in 2026 rather than 2025. But the argument is that it's unreasonable to expect the arboriculturist to include any sort of substantial tree risk in that survey, and a categorization of a yew tree marked identified as yew would suggest that it could be risky. I mean, there might be other reasons why it's not being included. But if I put my architect's hat on as the client or the designer, I'd want to know as much as possible if there were numbers of trees on a site. I'd certainly want to know about tree risk, because I certainly wouldn't spend my time trying to save a tree and incorporate it in my design if it was essentially risky. So should the designer or the client therefore also be requesting a more specific tree risk survey on the basis that the arboriculturist isn't able to guide them? And then who would do that? There's something sort of a bit messy. When I hear about a BS 5837 tree survey, I assume it actually tells me all I need to know about trees on or around that site. It seems potentially it doesn't really. And so how do we overcome that one?
Goodness me, if I could answer that question, I might be able to retire. Wow. I guess it boils down to having good people engaged at the earliest stage possible in the process. We've been saying this for decades now, that get somebody on board that knows what they're on about, that has got a good experience behind them, and get them in early. Being cutthroat about it on one side of the coin, when you have your ARB impact assessment, take advantage of those trees that are in very poor quality that may pose a threat to the safe use of the site, either as it stands or in completion. But the strongest, biggest but I could put in there is that sometimes those trees are going to be your ancient and veteran trees. Just because they look real peat and they're about to fall apart doesn't mean they're not a high retention value. So proceed with caution.
Oh. So I think in the chat, if one managed to analyze it, don't ask ChatGPT to, though, because I got it to try and tell me about the TDAG chat on one of our seminars, and it came up with complete rubbish. I couldn't believe it. But there's a lot of quite interesting things that are following on, and suggestions and counter suggestions and so on that are coming on that I think would be quite interesting to see what they actually were and how one might. It obviously picks up topics that are worth exploring further, whether as a tree law session or as a trees and design action group session. There are a lot of things in there that clearly aren't resolved. So you probably want me to hand back to you, Sarah, so you can wrap up.
Yes, please. Thanks very much, Sue. Thanks for keeping an eye on the the chat box and asking those questions to us. And all that remains really is for me to say a massive thank you to all the other presenters. So to Neil, Naomi, Adam, and Dom for helping me with the logistics behind the scenes. Thanks all of you for joining. This has been recorded, so you will get a copy of the recording as you are all delegates. And I'm delighted that you've attended, and thank you so much for making it such an enjoyable morning. Thank you very much, everybody. Bye now.